Welcome to Just Verdicts with your host, Brendan Lupetin, a podcast dedicated to the pursuit of just verdicts for just cases. Join us for in-depth interviews and discussions of cutting-edge trial strategies that will give you the keys to conquering the courtroom. Produced and powered by LawPods.
All right, welcome to another episode of Just Verdicts. I sometimes can't believe we've made it this far, but here we are, and I'm super excited today because I get to talk to one of my good longtime buddies, Rudy Massa, and Devyn Lisi. And it is Lisi, correct?
It's Lisi, but no, you can
Oh my
whatever.
God, I'm the worst. I am the worst.
Right.
Okay. I'm the worst. I sincerely apologize. You go over all the other checks of things that we have to cover, and I don't cover the most basic of things. So Devyn Lisi, thank you for being here. But yeah, I'm super psyched to have you both here. Obviously, Rudy and I have known each other forever, been studying the same stuff and passion and love of trial work and being on the right side of things, we like to think. And, Rudy, you have, you've provided me so much support, insight, advice, all kinds of good stuff over the years. So super psyched to have you on the show to talk about this great verdict that the both of you got. So first off, before we get into this, and I'm just going to keep with the theme of butchering names, is it Pschirer versus St. Clair Hospital and everybody?
It's Pschirer.
Of course.
She's not silent, but that's a common mistake.
Right.
I'm feeling very George Costanza-like today, where I know how to pronounce it and they're wrong every time. So anyway, so the Pschirer case versus St. Clair Hospital that the both of you got this great verdict on. But before we get into that, tell us a little bit about both of yourselves, the law firm, what you guys do, and your background, a little bit of your history.
Well, I've been around for a while, Brendan, as you may know. We opened the firm back in 2023. I've been off on my own, and every year we've added more and more talent, which would include Miss Lisi. I've a little bit of background. I was a chiropractic physician for many years in South Florida before going to University of Miami Law School, and then transplanted back to my hometown, which is the Western Pennsylvania area. The firm is, we do primarily, if not exclusively, medical malpractice and nursing home litigation. We do some vaccine cases. But yeah, that's all there is about me. I don't like to talk about me so much. Devyn joined us as a law student. So I'll let her talk a little bit about herself. She's been a fantastic trial lawyer. This was her first full jury trial as second chair, and she did an amazing job. She's an amazing lawyer, and we're just very honored and proud to have her as part of the team.
Thanks, Rudy. That's very sweet of you. So I'm Devyn Lisi, obviously. I had joined this firm back whenever I was a third-year law student as a law clerk. I had no intention of going into this practice field. I didn't really know anything about medical malpractice, and actually got involved because of two of the other partners here, Megan and Pete, and they were involved at the law school I went to. Got in here and fell in love with plaintiff's medical malpractice work. It's really incredible. Just getting to work with the clients and learn so much, not only about trial, but also about different areas of medicine and practice. It's a really interesting career. So I kind of wouldn't let them give me up. I made sure that I got a spot here. And yeah, it's been a great few years. I'm starting into my fourth year as an associate here, which has been awesome. And getting to this trial with Rudy has been incredible as well. It was a really good experience, and feel honored to have gotten to do the first trial with you, Rudy.
Oh, shucks.
No, but I think that's a fair point. I mean, in a sense, you're very fortunate, Devyn. Get in with a great firm, great people. I mean, I love everybody at your firm. But then to get to try your first case, working along with somebody that really knows what they're doing, like Rude does, and then getting a great verdict. I mean, I think I went my first 10 or 11 trials and getting zipped every single time. So to walk right in there and ace the test is fortunate. Although, maybe you should get used to it. Maybe you'll never lose. You'll be like Jerry Spence. But
Here's hoping.
it can be a tough and trying profession. I'm going to warn you about that right now. You can take some beatings at times. So enjoy it. I think it's wonderful. So let's get into this case a little bit. So Pschirer versus St. Clair Hospital. And if you don't mind, I haven't done this before, but I was reading your pretrial statement and I loved how you started this. So for anybody not familiar, the pretrial statement is a bit of a summary of your case. And most of the time it's pretty mundane. People just kind of, stack facts. It's kind of dry. People have different takes. Do you make it long? Is it persuasive? But I really liked the way you did this. By the way, who wrote this? Was it Devyn or was it Rudy?
I think it was a combination of all parties involved. In fact, we send around, not to belabor this, but we send around these narratives and we get the input of just about everybody in the office. And one of our other colleagues, Bobby Fitzgerald, had a hand in it as well. So I'll give him some credit as
well. Well, before I read it, tell me, what's your philosophy on pretrial statements? Because I, for the most part, I probably fall into the group that I don't maybe give them as much attention as I should, because I just figure we're going to trial regardless, and the judges, they're not going to do anything for me. So I'm going to give them, the other side, anybody, as little information as possible to maintain any secret advantage I have. But you guys, as you'll hear in a second, tell this very kind of compelling story. Why do you do that?
I think we know the judge is going to read it. So I think schooling the judge and getting them to understand in the shortest possible language what the case is about. And, that's important. What is the case about? It's not about sometimes the factual background. It's not about what happened at what time. It's about what the case is really about. And I'll talk about this later, but it's a lot. And we call these cancer cases lost chance of life cases. And I think that's a very powerful theme, and early detection is part of that. And we wanted to focus on that early on in the case.
So let me read this intro, because I think so many of us handle delayed cancer cases. This fact pattern is very similar to a number of cases we've handled in the past. So narrative statement to the judge starts as follows. Cancer, a word that evokes fear and despair. A disease that has haunted humanity for centuries. In the battle against this relentless foe, one principle has remained a beacon of hope for countless individuals, including every juror in Allegheny County. Early detection. Early detection is the crucial advantage in treating cancer, a home field advantage that can mean the difference between life and death. But when doctors and hospitals fail to provide this critical advantage, the consequences are devastating. For Cheryl Pschirer, this failure allowed the cancer to grow unchecked, robbing her of precious years she could have spent with her loved ones. This is her story, a story of a stolen future and a heartbreaking betrayal by those entrusted with her care. That is freaking good stuff right there. You could almost start your opening statement. That some people might argue with that, but with that, I love it. So good. So tell me, now that I've read that and I've set the stage, why don't you guys tell us about what happened in this case?
Sure. Thanks, Brendan. Yeah, and it was a very powerful statement, and we hope to support that theme throughout the case, and we'll talk about that a little bit later, about telling our story through every witness and making sure that the themes were consistent throughout. But what happened in this particular case, Cheryl Pschirer, 66-year-old female, lifelong smoker, 3 adult children, no surviving spouse. She had a live-in boyfriend for many years. At 66, she was pretty much at the end of her work life tables, but she was still working as a nurse. She had a cardiac history of 2 MIs and stents. So, some of the facts were stacked against us as far as the defendant. So we had to, in essence, try to make this case about something more than that. And that's where the early detection and the lost chance of life comes in. So the facts of the case are that in February 2017, Cheryl had gone to the emergency department with a rapid heartbeat. And at the time, a portable chest x-ray had been performed. The ED physician read it on the spot, didn't find anything wrong. And then that x-ray was sent to the radiology department. And 3 minutes before Cheryl left the ED, and the rapid heart rate had been ruled out, 3 minutes before she left the ED, the preliminary results came back from the radiologist that revealed that she had a mass in her upper right lung. That information was never passed along to Cheryl in the ED, and she was dismissed and discharged from the ED. And she was told to see her PCP and follow up. Well, she never did that. The PCP, one of the issues in the case, which we'll talk about a lot later, is that they had a process, not a policy, not anything written, that said that with incidental findings that those results would be faxed to the primary care physicians, which it was. And so the radiology report and the final radiology report got faxed to the primary care physician, who actually signed off on the report. Unfortunately, Cheryl was never informed by her primary care physician as well. Cut to the chase, 7 months later, Cheryl, in September of 2017, starts to have eye issues. She's got some vision loss. She sees her physicians. They send her for a CAT scan. Now she's got brain mets from what was primary lung cancer. So that's basically the case. There was a 7-month delay, and so she goes under chemotherapy, and she passes away in May of 2018. Importantly, in this case, her cause of death was from the brain mets, not from the primary lung tumor, because she actually had responded well to the chemotherapy and the radiation to the lung, but the brain mets, as you know, is pretty much a death sentence. So early detection was clearly our theme in the case, and along with that theme, established that she had lost her chance for survival. So this was, again, a lost chance of life case. So that's essentially the case in a nutshell. If you want to parse out the facts, I'm happy to do it.
Well, one thing I want to talk about is, when you first hear it, complete miss. They saw it. Nobody told her about it. Seems largely like a slam dunk. But talk with us about, because these are relatively, unfortunately, common cases that come up in the course of our practice. What are the hurdles, generally in delayed cancer, lung cancer cases, and what were the some of the specific hurdles that you both had to deal with and overcome in this case?
Well, and I'll let Devyn talk a little bit about them as well. But I think the primary issue we had to face was a causation defense. And that's getting a little more into the legal side of it. Defense wanted to argue that the 7-month delay was not enough, and that the care would not have changed had she even been diagnosed earlier in February of 17. One of their defendants attempted to argue, and we'll talk a little bit more about this when we talk about our Fry motion, wanted to argue that she was already at stage 4 cancer at the time of the earlier film. The second defense causation expert says she was at stage 3B. And just so your listeners understand, there are 4 stages of cancer: stage 1, 2, stage 3A, and stage 3B, and then stage 4 cancer, which is metastatic disease. Once you hit stage 4 cancer, back in 2017, stage 4 lung cancer with brain mets was pretty much incurable at that point. And so the defense wanted to argue, well, yeah, we missed it, but in fact, there wasn't anything that could have been done that would have changed the outcome. So I think those were our main hurdles: the damages, the short delay when it comes to diagnosing cancer, and whether or not she was stage 4 or stage 3 disease. Just to give you some numbers, and this we'll talk about later when we talk about the closing. An individual with a 3A diagnosis would have a 40 to 60% chance of a 5-year survival. A patient with 3B would have anywhere from 20 to 27% chance of survival, and patients with a stage 4 would have a 0% chance of survival. So essentially, by the delay, we had argued that they had taken that chance away from her because she had a 0 chance by the time she had brain mets.
I think another one of the big hurdles that we faced, especially in a lung cancer case, was that she was a smoker. She smoked for a long time. And I mean, by the time that she was diagnosed with cancer, she had cut back on her smoking, but it's still a really bad fact, right? To have to tell this jury that she was a smoker for most of her life. And another difficult fact is she continued to smoke after she was diagnosed with cancer. That was something that we definitely faced a heavy pushback from defense on, was that she was a smoker and they didn't give her this cancer. She was essentially, bound to die from lung cancer because she smoked, and that's not their fault, right? So we had to push back on that in some creative ways. We attempted, this was my uh, project. I was really passionate about trying to get the smoking out. I thought that it wasn't relevant to the case, right? It doesn't have anything to do with the negligence, doesn't have anything to do with the causation, because the causative question here isn't what gave her cancer. It's whether or not the delay caused a increased risk of harm. That unfortunately didn't go the way that I wanted to, although I think that our motion was pretty strong when it came to the motion in limine to preclude smoking. There's a really interesting case that went up to the Superior Court where they held that it's not necessarily relevant, even on these exact facts. A delay in diagnosis of a smoker, lung cancer in a smoker, that smoking is going to be more prejudicial than it is probative in the facts of a delayed diagnosis case.
Can you give a cite to that case? It's an unpublished case, Brendan, but it's very, I think, very influential as far as the rationale is concerned. And so you can make those arguments to the court. We didn't succeed in this particular case, and we had to make some adjustments just prior to trial because this was a motion to limit. But Devyn, if you can give,
yeah, that was the Palar case, Palar versus Wohlwend, Wohlwend, and that's a 2017 unpublished Superior Court case. But it's very similar facts. It was a delayed diagnosis, lung cancer, and she was a long-time smoker. And the court kept that information out of trial.
So two things I will add there. I've focus grouped this issue a bunch of times, and what I have found is if you don't say anything about smoking, people are still talking amongst themselves like they were probably a smoker.
Yeah.
So it's tough. I mean, I think you have to try to fight to keep it out because I agree with you. It's not relevant. And I'm familiar with that case. And the case stands for that shouldn't have come in. Did you think the fact that she continued to smoke and maybe there was either life expectancy or contributory as far as, care played a role in that? Or is it really just based on, some other rationale by the court and the argument by the defense?
I think that the court did think it was relevant to her life expectancy. Our argument was that wasn't an issue. The question was not her life expectancy, how long she was going to live, but rather the chance of survival that she was being given. Rudy talked about the numbers and the percent chance of 5-year survival rate. That was really how we had pursued this case. And there wasn't a contributory case that the defense really put in. They generally put out there, oh, she was a smoker. But there wasn't a dedicated contributory case that they put forth in trial.
And just so I'm clear, sorry, Rude, but was it your expert who was saying that she was 3A at the time that it was found, and they're saying that she's stage 4 at the time and it wouldn't have made any difference? That was the battle.
One of their experts said stage 4, the other one said stage 3B. But this victim blaming, we stumbled on a nugget, Brendan. I pulled an old deposition from one of their experts, the Dr. Kelly in this case. I'm going to read it, and this is just gold. This is blaming the victim. He was addicted to nicotine, and we're blaming him. We are. Society does this. And I believe this is wrong. We don't blame victims of other diseases. We don't blame patients with heart disease if they don't exercise, if they don't eat right. And I don't believe that it's fair to do that to people who are addicted to nicotine. That was their own defense expert who actually testified to that. And I read that quote to him on the stand, and I asked him if he recognized those words, and he says, yes, those are mine. So we stumbled on a couple of good things. And one of the other things with the smoking that we had to deal with, as Devyn mentioned, was the fact that, they were blaming the victim, but the primary care physician who had admitted the liability, said she wasn't there to blame anybody. And then we raised this in closing that she was blaming the victim for actually smoking. So we used it to our benefit, used a little bit of jujitsu there, and we tried to use that against them. Was it effective? Yeah, who knows? But
Well, it's pretty unusual. You'll see admitted liability most frequently in, say, car crash cases, things like that. So here, one of the individual defendant doctors admitted fault before trial.
Yeah.
correct. Yes.
And how did that come about? I mean, was there just a full-blown admission in a deposition, or was it more of a strategic, decision leading up to trial because they realized how much trouble, or both?
Brendan, I think it was a combination of both. I took the PCP's deposition, and it became clear to me during the course of the deposition that there wasn't going to be much pushback. And in deference to this PCP, I think she did the right thing. She had actually signed off on the actual radiology report. It was in her file, had her signature on it. There wasn't really going to be much that she was going to do that was going to. I think she would have lost a lot of credibility had she made that argument. So their primary defense in this case was the causation defense and the smoking defense and the things that we had mentioned earlier. So it became pretty clear. And then through the course of the actual trial, we did get a stipulation that she would agree to the liability in the case. So negligence was admitted on the jury form questionnaire. When it came to the PCP's name, the box that says was the PCP negligent was checked yes.
Okay. So who were the other? So you've got the PCP who gets the report, signs off, but never tells the patient, and essentially admits to negligence, before and during the trial. Who were the other defendants in the case? And tell me, what were your theories and why did you also have them in there?
Well, I think the greatest pushback that we got was that we were fearful that the jury would take an either-or approach with these defendants. In other words, the ED physician in the case who had seen the patient, who actually had a copy of the preliminary results that said there was a possible mass in the right lung, that report was there at the time of the visit. However, it was near the end of the visit, and she had discharged the patient prior to those results coming in. And the St. Clair Hospital, who actually did not have any written policies regarding these kinds of findings, informing the patient directly. So our theory as against the ED physician and the hospital was they failed to inform the patient directly of these results. They did, in fact, have a process where they would fax the report directly to the PCP. But I think what happened, and of course, they didn't find any negligence as against the ED in the hospital, was they believed that somebody had to tell the patient, and it should have been the PCP since they had faxed the report over there. So I think the jury took an either-or approach. Our experts testified to the opposite, that there was a direct duty. And in developing our rule in the cases, we use rules a lot. We try to create a rule that would make these defendants irrelevant, these defenses irrelevant. And so we use that as soon as a doctor knows something is wrong, their patient has a right to be told. They can't argue with that. And so we use that at trial. But I think ultimately the way the jury came down in this is that there was an admission of liability by the PCP, and they used an either-or, and the patient, that there was a satisfaction of that at least there was an attempt to inform the patient. Unfortunately, it was not directly by the ED nor the hospital. So
Gotcha.
That's kind of how that shaped out. Do you have anything to add to that?
I think that's, our defenses at the end, or the defendants that we had in this case, we had the two ED providers, the hospital and the physician, and then the PCP. It was almost like we had two separate cases that we were putting in. It was the ED case and then the PCP case. The causation, I think, kind of sticks along the whole way for both of the defendants. What's interesting, too, is for the PCP side of things, Cheryl did go to her PCP about
And they
3 months later, 2 to 3 months later, after the visit in the ED, PCP had this document and didn't tell her anything about it. She went for an unrelated cause or unrelated visit and still didn't tell her anything. So I think that the fact that Cheryl did show up to her PCP a few months later, I think that played a role as well in pointing back to, well, PCP knew and didn't say anything, had an opportunity to. Whereas with the ED provider, she was in there for one visit and never saw that ED provider after that day again.
Got it.
But I think, Brendan, we tried to focus the jury on the fact that the duty does not get absolved when that report gets faxed, because there are many things that could have happened in that process. Maybe they got the wrong fax number. Maybe it didn't get to the PCP. But the patient still had a right to be told by those physicians who've ordered the test. And that was, I think, the primary case we tried to put forth as against the ED doctor and the hospital, because I felt that very strongly, as did our ED expert, that duty doesn't go away just because you fax a report to somebody else.
I want to hit jury selection and then your approach to your case in chief. So, Devyn, did you guys have any, unique questions that you wanted posed to the veneer? And also, how did you guys approach your voir dire statement?
Yeah, so we were hoping not to get the smoking in, obviously, but because in Allegheny County, motions to eliminate are heard right before trial, so we had to prepare either way. Luckily, we knew going into voir dire that the smoking was coming in. We did ask the judge to argue that issue prior to doing our selection, and a lot of our questions really did circulate around the smoking and whether or not they would blame a smoker. We ended up getting quite a few smokers on our jury, which I think did help us because they're patients as well. They understand that they deserve care just like anybody else does. That was a large part of our questioning. The voir dire took a long time. We had an incredible time trying to get a sufficient pool of jurors, mostly because of hardships. A lot of people just had different hardships to excuse themselves for. We had planned to do jury selection for half a day, which I think was ambitious. And that ended up taking almost 2 full days to get through all of the selection.
That's pretty brutal. On the smoking questions, did you find a lot of people that had, for lack of a better term, a smoking bias, that they just couldn't get over the fact, hey, if you smoke, you accept that risk, kind of thing?
Yeah, there were some. I was rather surprised at the number of people who didn't have such strong opinions. Right. Now, I would say a lot of our jurors and people who were being questioned just in general had not very strong opinions one way or another. They took a very middle ground on a lot of the issues that we asked, which I thought was really interesting. I kind of assumed that people have strong opinions. Maybe it's just because I have strong opinions on certain things, right? And I have this idea that the public in general has strong opinions against plaintiffs or against doctors or for doctors. But the majority of the jurors that we interviewed, they had primarily middle ground opinions, with the exception of a few who had said some things I thought perhaps they were saying just to get themselves out of jury selection and not have to sit through a 2-week, 6-day trial.
One thing to add to that, Devyn, and I think you'll confirm this as well, is we heard a lot of jurors say it's personal choice. And that people are entitled to their personal choice. And I think that was a theme amongst the individuals who were not smokers. And I think that resonated a lot. And we liked the fact that, those jurors felt that it was a personal choice, and it wasn't their choice, but it was a personal choice. So personal choice played a big role, I think, in the jury selection when it came to that smoking issue. So that might be something that we might want to ask in future cases. Do you believe that individuals have the personal right to choose whether they smoke or not smoke? And then our theory of the case and our theme again was, hey, look, they still have the right to be told whether, you can't blame those victims. But anyway, that was interesting.
I would say one of the questions that we asked our jurors, and I'm not sure that this is I haven't done a jury selection like this with Rudy before, but one of the questions that was asked was whether or not you have an innate trust of doctors. I think sort of our thought process in using that question is, are you going to believe the defendants out of this? First and foremost, just because they're a doctor, are you going to believe their testimony primarily? But I think it kind of took a different twist in this case, where you're providing your trust to your physician as a patient, and you trust that your physician is going to tell you the information that they know. And in this case, Cheryl had a right to trust her physician, right? Patients should have a right to trust their physicians. And unfortunately, that trust was broken by not telling Cheryl what she knew. She didn't tell her that she had seen a mass in her lung. Had she told her that, then I think that would have changed the outcome of this case and changed Cheryl's outcome potentially as well. So I thought that was one of our more interesting questions that, you go in asking it in one way, thinking that it's going to have this certain impact on the jury selection. But it really turned out to have what I thought was a different impact. It helped us in the long run.
Because causation was such a big issue, always is in these kind of cases. I know I've already touched on it, so maybe I'm just a little dim. So your causation expert said that at the time of diagnosis, she was what, most likely 3A?
3A
Okay.
or 2.
Okay.
And so those percentages would change. I hope I didn't misspeak when I said earlier, stage 2 would have been a 40 to 65% chance of survival. But a stage 3A or even 3B would be 20 to 27%. I think I might have misspoke earlier. So our expert said she was either 2 or 3A. Their expert said, one of the experts says 3B, and then the ED causation expert said stage 4. And if we want to take a little bit of a side step on this causation issue, Dr. Kelly, who was the ED causation defense expert, we filed a Fry motion in this particular case, and I can talk just briefly about that. The issue with Dr. Kelly was there was no staging done in February, so it was very difficult to determine what her stage was because all we had was a portable chest x-ray, which, as you know, is just a frontal view, and so it's very difficult to stage a patient based on that because it requires MRI, it requires CT scans, biopsies, and the like. That couldn't have been done, so therefore staging was difficult. So as a result, Dr. Kelly, rather than talking about the various elements of staging, referenced a research article that talked about when is the best time to image lung cancer, whether it's stage 2, 3, or 4, and used that research article to determine the timing involved to go from stage 1 to 2 to 2 to 3 to 3 to 4, and said that because it took stage 3 to 4 would take about 1 year, he said therefore when she was diagnosed as having metastatic disease in September of 17, therefore she was already in stage 4 a year earlier, which would put her in stage 4 in February of 17. So that was his argument. We filed a Fry motion that said, look, you can't, this is not a methodology that oncologists use to stage cancer, that this is an inappropriate junk science, the typical Fry motion. The court was not persuaded by our argument. Unfortunately, I thought it was a very good argument, and I thought it should have stood up, but the judge was very overwhelmed by Dr. Kelly's CV and his credentials and said, how can you dare justify getting this expert kicked with all of this, 50, 60 page CV, hundreds of peer review articles. I said, well, I try to explain to the judge that it doesn't matter. You can have an expert here with a one-page CV. It's their methodology, and you can't rely on a research article in developing your opinions on causation when those oncologists don't use those kinds of things to determine whether or not they're at a different stage. Unfortunately, we lost that argument, but we were able to turn that witness into our witness with some of the things that he said at trial. The victim blaming was one of the things. And you know how sometimes we stumble into things. I did pull a copy of my cross-examination of him, Brendan, and I love this. We talked about them defending the case based on the negligence workup. And I said, there's a reason why we don't have staging in this case in February. And you're aware of that. He said, yes, I am. I said, it's because the defendants in this case did not follow up or inform Ms. Pschirer about the finding of her mass on the February 17th x-ray, correct? I said, yes, I agree with that. And then here's the punch. So you're relying to defend this case based on the negligence of these defendants to defend these defendants, am I right? And here it is. He says, no, sir, I am speaking to the issue of causation, which is whether there was an injury from the failure to follow the standard of care. So I'm not defending the failure of these defendants to follow the standard of care in terms of communicating the results of the chest x-ray. I don't defend that. I don't think it's defensible, and I'm pining on causation. So he actually testified that the conduct of the defendants in this case was indefensible. I read that in my closing. So sometimes a blind squirrel can find a nut every once in a while. So so that was good. So their causation, I didn't think their causation expert was all that compelling, and I think the court somewhat agreed with that.
Yeah, it's interesting because there was the Fry issue as to Dr. Kelly, I think, was particular in this case in that we had 3 experts on causation. We had our own expert, we had Dr. Kelly, who was the expert for the emergency side of the case, and then there was a separate causation expert for the PCP. I think that having those 2 separate causation experts for defense, one who says she had stage 4 and the other one who said she had stage 3B, really cut against the defense. And the physician who had for the PCP, the causation physician for the PCP, Dr. Hoffman, who said it was 3B, he used staging. He identified this is likely what her staging was using the traditional staging criteria in February. And that's what we partially argued in the Fry motion as well, was that, look, our expert does it this way, the PCP defense expert does it this way, this guy is the only one who's using this research article. It doesn't make sense that he would do that. But again, the court wasn't persuaded by it. Although I will say that the Dr. Hoffman, the other defense expert, whenever he testified on causation, I think that he aligned pretty closely with our expert. The difference between 3A and 3B isn't dramatic. I mean, there is obviously a difference, but it wasn't incredibly dramatic. The percentage of survivability at that point is pretty similar, 20 to 27%. I believe it's like 20 to 25 for 3B and 20 to 27 for 3A. So negligible, really.
Did you consider or did you confront Hoffman's with the testimony of Kelly to, in either to undermine one of them or to undermine Kelly in any way? Or did you try to stay pretty separate as far as those opinions?
There's a reason why, Brendan, we didn't do that. And I'll tell you why. We were successful in getting Dr. Hoffman, the other causation defendant, to pull back from the stage 4 cancer diagnosis that Dr. Kelly had given. So we didn't want to open the door there, since Dr. Hoffman said he wasn't going to testify that she was at stage 4, but had we opened the door, that may have come in. So we wanted to avoid that. So that's why we didn't do that.
He wasn't definitive on the stage 4. In his opinion, he said you couldn't totally rule it out. She could have had stage 4. So we didn't want to address that on testimony, that he might have thought she could have possibly had stage 4, and then suddenly it becomes a lot more blurry. And we would rather stick with she was in that 3 range in February.
So we've talked a lot about causation, which is obviously, as everybody can tell, such a big issue in delayed cancer cases, certainly lung cancer cases like this. Talk to me a little bit about damages. What sort of testimony, what was your order of proof? How did you lay it out? And, you've talked about this theme of loss of chance of life. How did you try to work that in? Because I presume, I know because of the way the caption is that Ms. Pschirer unfortunately passed. So family members, friends? What did you have in that regard?
I think Devyn did a great job on some of these witnesses, and I'll let her talk about her witnesses. We wanted to try to utilize a little bit of Joe Freed's technique on the speed trial. We tried to get people in and on and off very quickly. We called each of the surviving adult children, which was a son by a previous marriage and 2 daughters. I had called Barbara, who was our plaintiff in the case, and I had called Jack, who was her surviving boyfriend, living boyfriend. Devyn had called a coworker who really gave a very, very compelling testimony and actually had been helped off the witness stand because she broke down and cried. Some of the jurors were actually, Devyn noticed, were in tears. And then we called one of the daughters, Marlene, who had a bit of a troubled past. I don't want to get into that and reveal any of that, but she had a bit of a troubled past. And so we called, those were our conditioned witnesses. And Devyn, I'll let you talk a little bit about who you deposed.
Yeah, so we had a really interesting family dynamic here. I think that in some ways could have cut against us because she didn't have a spouse, right? I don't believe that she'd been married twice before, but her kids really loved her deeply. That was something that came across clearly in all of their depositions leading up to the trial. A sense that we sort of got in preparing for this trial was what kind of a person Cheryl was. And we really wanted to display that to the jury. Her kids, while they all were wildly different people, they had the same story, which was their mom was their best friend. She did anything and everything for them. She had a couple of grandkids. Her son had a few kids, as well as her youngest daughter had a couple of kids as well. So we brought up some testimony about, her grandchildren, things that she did. We talked about specifics. What was unique in this case, we don't see this very often in our cases, her youngest daughter did rely on her financially for a period of time as well. We talked about that. I do think that, having somebody who wasn't familial, her coworker to testify was incredibly helpful. So Cheryl was a nurse at a nursing home. She actually was a straight supervisor at the nursing home and had worked there for a long time. One of her coworkers who worked with her for probably like 5+ years, they became really good friends. And she worked under Cheryl. She was a nurse there as well. And they became friends. Kim was her name. Kim testified beautifully. She was able to talk about the type of person she was at work, the type of person she was with her kids. And she was really a strong voice throughout her deposition, through her testimony as well. It was at the very end of her deposition that I think it sort of
Trial.
Yeah, at trial. It really hit her that she had lost this friend and she just broke down. I was not expecting it at all. That didn't really fit with the Kim that I had known or talked to leading up. And she just really broke down. It was difficult to watch myself. And there were a couple of moments, not only during her testimony, but during some of the other family members' testimony, Barbara, especially our plaintiff, as well as the youngest daughter, Marlene. When I had looked over at the jury a couple of times, there are a few of them who had gotten emotional during this testimony as well. So
I do recall one of the things that, Barbara talked a lot about her mom's love of music and dance. And that was an important part. And one of her favorite songs was Don't Worry, Be Happy, and so Barbara's testimony concluded with, they were all around. Her mom was not going to make it, and she was told them to don't worry, be happy. And we ended on that. And with Barbara, it was very compelling. I thought that the case came in, Brendan, very well. One of the things that I did want to mention that we didn't do in this case, which I think was very helpful, we didn't chase the defense. We told our story through every single witness, including some of the defendants in the case. And I thought it was very powerful. We stayed away from one of the ED physician was especially argumentative and combative, and I did not want to call her in our case, which I always call the defendants as on cross, but this was one exception where I didn't want to muck up, some of the story that we were attempting to tell. And we did not chase the defendants at all. We didn't chase their case. We told our story for every witness, and including our conditioned witnesses, and I think it came through, very nicely. And then one last point to that, as far as telling our story, and I listened to Satch Oliver recently about depositions, how important they are. The three things about telling your story is depositions, depositions, depositions. Being able to set up those sound bites to be able to repeat at trial is just absolutely gold. And that allows you to tell your story at trial with these witnesses, because they can't impeach themselves. One of the other things that I think Satch Oliver talked about in our recent conference was try to get that summary question out there. You can get your individual questions, but then get a summary question out there. And he even talked about using a document with true-false questions. Is this true? Is this true? Is this true? And then have them check each box that says true or false. And you'd be surprised how powerful that summary statement can be in opening and closing as well.
I want to circle back for a second, if I can, on the damages. We had a really tough time with damages in this case, obviously. If she was diagnosed, our experts saying 2, but probably more likely 3A cancer, stage 3A cancer. And the chances are there, but they're not great. And she was a smoker. She didn't have the best health. She didn't have, a spouse. She only had children, but they were all adult children who had primarily, by the time that she was diagnosed with cancer, been living on their own. Even her youngest daughter, who had some financial dependency on her, had pretty much worked that out and was on her own by this point. So damages were a tough aspect of this case for us. So what's really unique about how we kind of framed it was a loss of a chance of life, right? That's the phrase that we use whenever we're talking about cancer type cases, is a decreased chance of survival. And Rudy had a really strong closing point on this that I think was incredibly helpful. And I think you have it to share with us. It's such a strong way of presenting these delayed diagnosis cases where we have a decreased chance of survivability.
Yeah, I can, Brendan, whenever you'd like, I could read that.
No, please. I think everybody's always, trying to come up with ways to reframe, what the damage actually is to help the jury kind of better understand it. And you had sort of touched on this in an email to me. So yeah, please tell me, sort of how you conveyed this to the jury.
So this is kind of how I came up with it. And actually, Devyn and I kind of went back and forth on this issue. There are a few concepts that we wanted to try to establish in closing to get the jury to try to quantify what exactly is a lost chance of life worth. And so I came up with this in the closing hours before my closing. And so here's how I'll just read exactly what I said to the jury. As for the amount of damages, I'd like to talk to you a bit about that. So what is the chance to live worth? Imagine this. A woman is driving her car, heading down a familiar road, maybe even heading home to be with her family, just another day, thinking about what's ahead, her plans, her life. Then out of nowhere, time stops. The whole world pauses. Everything goes still. Her heartbeat is the only thing she can hear in the silence. Suddenly, there's a knock on her window. She looks over, startled. A man stands there, looking at her calmly, opens the door and speaks to her in a soft but serious tone. He says, "You're about to be in a terrible accident. A life-changing, life-threatening crash is going to happen. There's absolutely nothing you can do to avoid it. Here's the thing. You have a chance. In this bag, I have survival chance cards. Each card gives you a 1% chance to survive. The more cards you take, the better your odds. How many would you like? Now, I want you to think about how precious life is. What would Cheryl do? How many cards would she take? Would she take just one card for a 1% chance? 2? Would she take 5, 10, 20, 30? Well, the answer is simple. She'd take as many as she could. She wouldn't hesitate because every card matters. Every card could be the difference between life and death. Every card is a chance to go home, to see your loved ones, to live another day. Now think about the value of each one of those cards. What is each one card worth? What is the value for just one card, a chance to live? One more chance to keep breathing, keep living. Think about what Cheryl lost when she didn't get those chances. Think about the things she'd miss or her family would miss. More dinners, more legendary holidays, more hugs from her grandchild, concerts with Jack, dance parties, or even to see her daughter Barbara finally get married. What is the value of these moments? What would one give to hold on to those moments? Cheryl never had the opportunity to take those cards. She never got played her hand because her chances were stolen from her. She didn't get the chance to decide how many chances she'd take to survive because they didn't tell her about the mass in her lung. That choice was taken away from her. Instead, the people who were supposed to protect her, who were supposed to inform her, let her walk out of the hospital completely unaware that her body was fighting a deadly enemy, a battle she could have had a fighting chance to win if they had only told her. Cheryl was robbed of the opportunity to grab those cards, to hold on to life just a little longer. She had a chance. Maybe it was 40%, maybe it was 65%, maybe it was 20%, but that chance was hers and it was taken from her. Now it's up to you to decide what each card is worth, what each percentage of life that was taken away is worth. What was the value of that lost opportunity to live, to have another moment with her family, to laugh, to love, or to dance? That's what you must decide. You can start by determining what's the value of a 1% chance to live. Once you've decided what that value is, then multiply that value by the percentage of chance that was taken away from her. If you believe Cheryl had a 40% chance of living, then multiply your value by 40. If you believe she would have had a 20% chance, then multiply your value by 20, because that's what Cheryl lost. We know that we can't bring Cheryl back, but she deserves the justice to make these defendants pay for what she lost, a chance to live.
Awesome.
Yeah,
And I
so
like
I
that.
fight back in tears when reading that because I was looking at the family at the time. So yeah.
What I think it's, I mean, it does a couple, there's a bunch of stuff in that is great. One, it's the, loss of choice that she has. This is going to happen. There's nothing you can do about it. Now you get to, this crummy decision of picking these chance cards out. But I like that, then there's also some degree of guidance to the jury of a way to think about
Right.
assessing damages, which we all know in Pennsylvania, where we can't suggest an amount of pain and suffering or, wrongful death or survival damages. Anything that you can provide them in that regard helps, because inevitably people are always saying, well, how do I know? Like, how do I know how to come up with what the fair value would be? So I think that's really, really interesting and really effective. So you give that compelling argument. How long was the jury out for deliberations?
Yeah, and just one last thing to add to that, Brett.
Please.
I did run this by Nick Raleigh, as you know, is our hero when it comes to these types of cases, and he absolutely loved it. Thought it was I can't. He said it was great. He loved it. Thought it was beautiful. But the jury was out. How long did it go?
We sent them out probably around 11:45, and they came back. They actually came back with a couple of questions, which that's a gut punch every time you get a question. But they ultimately came back. I would say around 4 was whenever they came back. So what's that, like 5 hours?
No, that's a pretty serious deliberation. Did you talk to them at all, or get a sense of like what they were deliberating over, and how did they come up with the verdict?
Yeah, I think it gets back to what I was saying earlier, Brendan. I think they saw it as a binary issue, like an either or, and I think they ultimately felt that since the primary care physician had the ability to inform the patient, and that opportunity was lost, I think they felt that the hospital and the ED doctor had done enough. In other words,
Okay.
they had faxed the report over, and that was good enough. That satisfied, and I think that's how they ended up, at least from the jurors that we talked to.
That seemed to be the big pushback, was the the negligence question on the ED doctor and the hospital, whether or not they had some sort of responsibility in this. Seemed like they had a good discussion on that. And then they did send back a question as to, what I think it was like, what is causation?
Yeah, like what, and then and then they asked, is there any limit
On
on
damages,
damages?
which was a great question to hear as a plaintiff's attorney.
Well, you're probably sick after the causation question, and then
Yeah.
you're loving the damages question.
Absolutely. Yeah, absolutely.
And, one thing, Brandon, I wanted to add, and I know we're probably running close to the time here, but one of the things I wanted to kind of share with you that our expert, causation expert, did, which I thought was, and he was very, he did connect with our jurors. He was Polish, and he spoke with a little bit of an accent.
Yeah, accent for sure.
And one of the things that he said, and I asked him, why did you want to get into oncology? Because he's a very bright man. He was a Mount Sinai guy. And I said, well, why did you want to get into oncology? And he says, well, he said, when I came to this country, he said, I had three concerns. He said, I had fear, I had hope, and I had a language barrier. And he said, and so when I wanted to get into a specialty, he thought, what better specialty than to get into an oncology? Because when my patients come to me, they come to me with fears, hopes, and a language barrier. And I thought that really connected with those jurors. They really, I thought that made them really connect. Not unless you have an expert who has from another country as a language barrier,
Yeah.
I can't use that. But I thought it was especially sweet, and he was a very good teacher, and I would recommend him very highly because he related very well to the jurors.
No, it kind of gave me a chill just hearing him. You recount what he said. That's pretty good. What was the verdict, and how did they apportion it, given that this is a survival and wrongful death type case?
Right. I can't really get into that because we're in negotiations right now to try to get the case resolved. But it was a
Gotcha.
$750,000 verdict. I can give you that.
And was the entire finding of fault on the PCP who never reported on the okay?
Yeah. No.
And I mean,
for both of the ED doc and the hospital.
Yeah, and I find that jurors, they want to do a good job. There's a lot of uncertainty as a juror, and when they are presented with, look, there's one doctor who's essentially admitted they were at fault. There's these other ones that are strongly defending their care, even though maybe there's a real question whether they were at fault. I mean, they're going to kind of probably take that. It's kind of the easier path, for lack of a better point there. Almost like a joint tort situation, almost an empty chair in a sense. So it's not totally shocking to me that it worked out that way. I mean, on the one hand, it is, though, because you're like, well, she was right there to be told, and how does nobody call her? But it's like if they did just the bare minimum, whereas the other doctor admittedly didn't, that's where you're going to wind up there. Can I go ahead, Devyn?
Yeah, I was just going to say, I do think one of the things that played into that also was that the primary care physician was asked by counsel for the hospital whether or not she puts any blame on the emergency doctor. We obviously objected to that and said that's not appropriate to ask the primary care physician whether or not she has any blame for the emergency doctor. That's a standard of care opinion from a person who's not of the same specialty. The judge said she's experienced, sort of similar to the ruling when it came to our Fry motion. Well, she was experienced with emergency doctor. She's a PCP. Let her talk about it. And her statement was, no, I have no blame for anybody but myself. I'm the only one to blame here. So I think the jury believed that, right? Somebody's sitting up there and says, it's me, put it all on me. They're going to do it. So that's what they did.
Oh, if only, they had just dumped all over the ER and the hospital as a surprise to that question. That would have been great. But yeah, I mean, that's pretty, again, that's the kind of testimony jury's going to latch on for their decision-making process. So I just have to go back. There were three things, Rudy, that you mentioned, and just my curiosity, I need to dig back into these, even though this would normally be a very good stopping point, and normally you would say, end on that, the high note of poignance and everything that we've hit so far. But Rudy, you talked about you didn't chase the defense. Can for listeners, for anybody out there, what does that mean? What is the trap we can fall into, and how did you try to avoid it here?
Yeah, I think that it's a good question. And we generally, you and I have talked about this many times. We use the template opening and the template closing. I got away from that. I didn't do that. They're expert. This is who we're suing and why. I didn't do any of that. So I did not. I told our story from the very beginning, and I told our story through each one of the witnesses. And we pushed our theme throughout. Like every doctor, their patient has a right to be told. And we pushed that theme throughout. And we did not focus on the smoking. We didn't focus. We didn't put in any economic damages. We didn't put in any issues regarding how much money she made per year. So I felt as though that we were their defenses would have been, well, she was at the end of her work life. Well, she didn't, she was a smoker. Well, she had all the. We didn't chase all those things. We didn't chase her cardiac history. We didn't chase her smoking history. We didn't chase the economic issue. We didn't chase any of those primary issues. We focused on the causation and the lost chance of life.
Got it.
So I think that's as best I can explain it.
No, I think that's, it's the same. It's kind of, whether it's sponsorship or, focusing. I mean, your case is about what you focus it on. And if you spend the whole time focusing on, more defense friendly topics or issues that the defense wants to talk about, then you're kind of undercutting, your case in a sense. So I get what you're saying there. You also talked about the importance of trying to get those admissions and those sound bites in the depositions that can potentially then be used effectively in trial. Did you do that at all in this case?
Well, yes, and I'll let Devyn talk about that a little bit more because we use a lot of the deposition transcript from the PCP. We also, of course, we don't get an opportunity to do expert depositions, but we use a lot of admissions from the expert reports that told our story as well. We in the defense's case, I did get a chance to cross their ED physician, and as much as I tried to use the sound bites from the deposition, she fought me on everything. I think that made it kind of her look bad in a way. We didn't get quite the ability to get the sound bites, but I thought Devyn did a nice job on calling the PCP as on cross and using a lot of the deposition testimony from her deposition, which I thought was very effective because there's no fighting back. You've got the deposition testimony. They're not going to impeach themselves. Generally, the defense attorney has provided that deposition to them multiple opportunities. So they know what they said in deposition. They're not going to stray far from that. So if you've done a nice job in the deposition, you've set them up nicely to tell your story. You just take them through trial. You take them through what they've admitted already in the deposition, and then you let the defense come back and do whatever they need to try to do to kind of, rebut that.
Yeah, this was a unique case for me because it had started before I ever started this firm. So the depositions that were taken I wasn't really a part of them. So Rudy had actually done a deposition of the PCP. But what's so nice about the way that Rudy conducts depositions is that he doesn't shy away from anything. He'll ask everything and anything during a deposition. So when it came to preparing for my cross of this physician who had already admitted negligence in her deposition, I started right there, right, with all of the admissions and the lines that she said or the things that she admitted, and put those, in a neat, orderly fashion to say, all right, you admit this. And I think a lot of yeses. And it was just yes, 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 yes. And she didn't push back on me. It's really interesting, though, because she did push back on Rudy on one thing in her deposition. And I wanted to pull that out, that she was pushing back on it during her cross as well. She pushed back at the fact that early detection of lung cancer can help a patient. She wouldn't totally admit to that. She was sort of hem-hawing and saying, I'm not an oncologist. I can't say definitively that, early diagnosis is good for lung cancer. So I brought that out. I said, lung cancer, obviously you want to detect it earlier. And her answer on the stand was the same that it was in the deposition. I can't really say one way or another. I pointed that out to the jury. So you're telling us you're not sure whether or not early detection is good in lung cancer? I don't think that they bought it very much. It was a strong point to be able to push back on. And that was just a ridiculous sentiment that was made in her deposition that I wanted to show to the jury, right? Like, this is a ridiculous defense to be pushing back on or using. She's trying to kind of throw something at the wall because she admitted that she breached the standard of care. So it seemed like she was pushing back on the causation side, even though she herself says, I'm not an oncologist, I can't tell you one way or another.
Yeah, I think it just goes sort of to her overall credibility and the vibe, and it's going to make it easier probably when you get that kind of testimony that just doesn't make sense for the jury to further find against her. I want to just kind of make two last points. So one, regarding, getting those good admissions and depositions, I think, Rudy and Devyn, I'm sure you're, starting to attend all the MedMal seminars. There's always this debate of, do you call the defendants as on cross or do you let them go in theirs? And I really think that in those situations, and why, Rudy, I know you feel this way, it's so important to try to get sound bites, to try to get those video clips, because that's almost the best of both worlds. Because if you pick up those really good video clips or admissions in the depositions, you can put those in your case. A, you know what you're getting. B, they're good. And then it kind of solves the problem of, do I call them now? Do I call them later? I mean, it's kind of that perfect middle ground. And, our friend Sandy Newman, I know, used it really effectively in her recent verdict a few months ago, where she was just playing these really effective clips of the hospital witnesses. And it was sort of like, she didn't even have to call those people in her case. And then by the time they testified in their case, the die was already cast. And then the last one I'll just say, and, you guys can both laugh about it now because you won and you got this great verdict for a righteous case. But in the moment, losing these motions is gut-wrenching and it's devastating. But then when you win, you're like, well, thank God, because it's one less appealable issue, right? So that's your silver lining, right?
I told Rudy when we lost them, I said, this is our karma, right? We lose something now so we can win at the end. At the time, I just kept trying to remind ourselves of that because it stung to lose both of those motions on the same day, too.
Yeah.
Put all that work in, you're on the right side of it, and you just get smashed. It's rough, but you're right, Devyn. That's a good thing to keep in mind, and look big picture. So anyway, thank you both. Congratulations again. You obviously did an amazing job for this family on a difficult case. I love this. I love this podcast because, you sort of hear things about a case and you're like, oh, that sounded like, anybody could have won that case. And then you dig into these cases, you hear the details and all of the, hurdles that you had to to overcome in this particular case. It's great lawyering that led to this. Congrats to both of you. And, where can people, they want to pick both of your brains about, how you did this, your different arguments. Rudy, like Rick, Nick Rowley, they want to hear more about your wrongful death closing arguments. What's the best way to people to contact both of you?
Our website, massalawgroup.com. Hit us up. Our phrase is, when the medicine hurts, call us first.
Oh, I like that. You got to make a t-shirt and send me one. Well, thank you both again. Congrats. And see you both soon.
Thanks, Brendan. Appreciate it. Take care, buddy.
If you enjoy the show, please subscribe to the Just Verdicts podcast on your favorite platform and consider leaving a review. And if you're interested in co-counseling, local counseling, or referring a catastrophic injury case, we'd love to work with you. Call us at 412-281-4100 or visit our attorney referral page at pamedmal.com/refer. Thanks for listening.